Well, it's another Tuesday, and yet again, 3:30 has hit the clock this afternoon. Welcome to Wheel of Justice, a program that is brought to you by the Abia State Administration of Criminal Justice Monitoring Committee and Prisoners Rehabilitation and Welfare Action Prawa, with the support of the Open Society Initiative for West Africa, OSIWA, and Abia State Justice Reform Team. This program is aimed to help us better understand the administration of Criminal Justice Law 2017. My name is Ifeanyi Awa, and I'd love to welcome you to today's edition of the program. If you do remember, last week we looked at the warrants of arrest from the previous sections. We looked at from sections of 35 to 42, and that was the first part of this. Well, today we'll be looking at same issue, warrants of arrest, but it's going to be under the sections 43 to 49 of the Acjl 2017. Now, I have a guest right here who's going to be breaking it down so we can all understand what this is all about. But before that, I'd love to take a quick breather. Right, still Wheel of Justice right here on your radio flow 94.9 FM. Don't forget it comes your way every Tuesday from 3:30 p.m. And yet again, this is brought to you by the Abia State Administration of Criminal Justice Monitoring Committee and Prisoners Rehabilitation and Welfare Action Prawa, with the support of Open Society Initiative for West Africa, OSIWA, and Abia State Justice Reform Team. Now, quickly, my guest for today is a Chief Magistrate Grade 1 and the Abia State Judiciary in the person of His Worship OK Onoma, and he is going to be looking. We're going to be looking at the warrants of arrest under Section 43 and 49 of the Acjl. Welcome to our studios.
Thank you. My pleasure to be here.
All right. It's also important that I acknowledge the presence of Kelechi Imo, who I always call him the Observer, the head of the Observer team. He is representing Prawa right here. Kelechi, it's always good to see you as usual. You're looking good today. All right, quickly, let's dive into business. Just like I said earlier, last week we looked at the warrants of arrest, starting from the sections 35 to 42. Now we're going from 42 to 49 of the Acjl. Last week we understood what the warrant of arrest is. We understood when a warrant of arrest is given and what is involved, the things involved in a warrant of arrest. Now, looking at this right now, what are the key areas when it comes to sections 43 to 49 of the Acjl?
Well, beginning with section 43 sub 1.
Okay.
It says a warrant of arrest may be executed on any day, including a Sunday or public holiday.
Okay.
So once a security man has a warrant of arrest, he can, no matter the time of the day, no matter the date, no matter whether it's public holiday or Sunday or anything, he can execute it. That's the implication of subsection 1 of section 43 of the Acjl.
All right, now also looking at the part of it being carried, let's go to the part of subsection 3 of 43. It says the police officer executing a warrant of arrest shall, before making the arrest, inform the suspect to be arrested that there is a warrant for his arrest unless there is reasonable cause for abstaining from giving the information on ground that it is likely to occasion escape, resistance of or rescue. Now, could you break this down for us?
Yes, it's very simple. A policeman cannot just come and
arrest you
or begin to bundle you or take hold of you. He has to inform you, I have a warrant for your arrest, before he commences the process of arrest, which is to tap the person and say you are under arrest. That part of it is not in this law, but that's procedure.
Okay.
So this provision says you have to show the person the warrant of arrest, possibly see your name on it, and perhaps inform the person of the offense the person committed, and then begin the process of arrest. So that is what the policeman has to do. But where the policeman suspects or feels that doing that may frustrate the arrest, for example, the person may escape, the suspects may resist or organize some people to come and rescue him. So in such a case, the police officer need not show the warrant to the person or suspect to be arrested. That's the implication of this subsection 3 of section 43.
Okay. What if in a situation where a warrant of arrest has been given, and yet a police officer who carried out this arrest is not without warrant of arrest? What happens in such a case?
Surely, that's just the provision of subsection 4. If a policeman knows there's a warrant in existence, there's a warrant for the arrest of a suspect, but at the moment perhaps that he saw the suspect, he didn't have the warrant, he can go ahead and arrest the person and say, there's a warrant for your arrest, but I will show it to you as soon as possible or as soon as practicable. So he can go ahead and arrest without showing the particular warrant to the suspect. So, and show it to him subsequently or as soon as practicable later. That's the provision. So there's an exception to the rule that anytime an officer comes to arrest a suspect, he must display the warrant of arrest.
Okay, doesn't the individual who is being arrested have a right to say no to the arrest since it's not seeing a warrant of arrest at that point?
Yes. Well, you don't have a right under the law. After all, there are situations where you can be arrested without a warrant. So if the police officer tries and informs you, I really have a warrant for your arrest, duly signed and executed by the person who should sign it, but I am not with it. I was going to so and so place and suddenly saw you. So come with me. You're under arrest. I will show it to you when we get to the station. There's any reasonable suspect, if there's anything like that, should comply with that. Should comply with the arrest. Should cooperate with the arresting officer.
Okay, now let's talk about, because last week was covered that any officer can carry out an arrest once a warrant is issued out. Now, another issue we covered last week was the fact that a warrant covers a particular area, depends on the court that gives that warrant.
Yes.
Okay. Now, at what stage does a warrant cover the nation? Covers the whole nation?
Well, just like jurisdictions of court differ, so also warrant. A warrant issued by a judge within the state certainly covers
the
state. Then, like that Federal High Court has the whole of Nigeria. So anyone issued by one judge covers it. But the law has provision for what to do if a warrant issued by a particular court is to be executed outside the jurisdiction, outside the area of influence or power of that court. You can, the law provides in section 46.
Okay.
Section 46 is detailed and full of technical words, but the implication is this. Let me break it. The one court issues the warrant, and it is to be executed in another area of influence of another court. The provision is that the police officer or security agent who is going to execute the warrant should take it to a court in that place where the warrant is to be executed.
Okay.
Take it to a court there, so that the court will take notice of it or record of it and kind of approve or confirm that the suspect that is within that jurisdiction, within that division, should be arrested before the policeman will now go ahead to go and arrest. And after the arrest, the officer will bring back the suspect to that court, that home court that has authorized the arrest of that suspect.
I'm so sorry for coming in here. You're saying, just to make it easier for us to understand, you're saying that once this suspect is arrested outside of the jurisdiction where that warrant was given, whenever he's arrested, he's taken back to the court where that warrant was given.
No, not that court.
Okay.
There will be two courts involved here.
Okay.
You can call them foreign court and home court.
Okay.
A home court issues a warrant.
Sorry, can we use states so it's easier for everyone to understand? Now, let's say it warrant was given in Abia State. Suspect is somewhere in Abuja.
Okay. Let's say a warrant was issued here in Umuahia.
Okay.
To be executed at Abuja.
Okay.
The police officer goes to the area in Abuja where he knows that the suspect is located. He will then locate a court near that place or situated in that place.
Okay.
And inform whoever, whether the judge or magistrate, that this is the position. We have a suspect who is found here or hiding here, and we have a warrant to arrest him. The judge or magistrate at Abuja will then authorize the arrest of that person. And when arrested, that person will be brought to that court at Abuja.
Okay.
That court at Abuja will then say, okay, take him to the home court that issued the warrant.
Okay.
That's what is done.
All right.
In some cases, that foreign court may even grant him bail. Yes, that foreign court may say, okay.
The issue of bail. We're coming to the issue of bail very soon. We're coming to the issue of bail next. But if you're just tuning in, this is Wheel of Justice, and it comes your way every Tuesday from 3:30 p.m. on Floor 94.9 FM. It is brought to you by the Abia State Administration of Criminal Justice Monitoring Committee and Prisoners Rehabilitation and Welfare Action Prawa, with the support of Open Society Initiative for West Africa, OSIWA, and Abia State Justice Reform Team. I've been speaking with His Worship OK Onoma, who is the Chief Magistrate Grade 1 in the Abia State Judiciary. We've been looking at warrant of arrest under sections 43 to 49 of the Acjl 2017. Now, the idea behind is to make sure that we understand what an arrest warrant is and the things involved in it, so that we do not fall into the wrong hands when this does happen. Now, let's go into the issue of bail. When can bail be given? Under what criteria can bail be given?
Section 45 of the Acjl gives one instance. That is, we are not talking about bail generally.
Okay.
We are talking about bail of an arrested person that is not yet in court. Bail of an arrested person, or bail in connection with warrant of arrest. Section 45 provides that a court issuing warrant of arrest may endorse bail on it. When issuing a warrant, I could say this offense is not too grievous. When that person is arrested, release him on bail until the day you will now produce him before me in a court. That's the purpose of the bail, so that he could prepare. So the court will endorse, that's write out the conditions of the bail on the warrant of arrest. That's what we mean by endorsement of bail. What does the court endorse? The court can say, okay, when arrested, 1 or 2 shorties will take him on bail. The shorties will be prepared to forfeit the sum of so and so amount to the state if he fails to appear at the court that will require him. Then he is expected to appear at the particular court that will require him on so and so day. These are the details a court issuing warrant of arrest, but once the suspect to be released on bail will endorse on the warrant. So when so endorsed and a policeman arrests the suspect, the policeman will comply with those conditions and later forward the papers to the court, to that judge or magistrate who issued the warrant. We have complied with your directives or order. 1, to arrest this man. 2, to release him on bail. He was duly released on bail. Look at the papers. The court will take it up from there. That's one of the conditions. The other condition or situation, that we are talking about bail under warrant of arrest or bail in connection with warrant of arrest. The foreign court, I mentioned the foreign court or court in Abuja, for a warrant issued here to be executed in Abuja. That court where the policeman takes the warrant to register it or to authenticate it, can say the man should be released on bail pending his appearance at the court that wants him.
Okay.
Pending his appearance at the home court where the warrant originated from.
So just to get this clear, bail can be applied at the foreign court.
Yes.
That is at the court in Abuja.
Yes.
Okay. Now let's go into part of this section. I saw a part of recognizance, and when can be discharged or with or without sureties approved by that officer. So are there places where surety is needed?
Yes. A surety is the person who will take the suspect on bail. A surety is needed when the court says so.
Okay.
In absence of a surety, the court could say, okay, we know you. You are important. You are that man at so and so place. Go in self-recognizance. So either the court says bail to you with 1 surety or 2 sureties, or you don't need to bring any person. Sign and go. That's self-recognizance. So that is the meaning of surety. The person that will sign the bail for you. Then the papers the person will complete, and the police will also complete, or court will complete to facilitate your release is the recognizance. When recognizance is mentioned, it's just that paper that authorizes you to be on bail pending your appearance in court that ordered for your arrest or pending your trial.
Okay. Now, there's also a part of this that states that in an issue where there's a death penalty hanging on, that this person might not be granted bail.
But yes, now if we are talking about bail generally, a person accused of offense involving death penalty will not easily be granted bail. So, assuming that the offense for which the suspect is being wanted or is being arrested involves death penalty, that foreign court may not release him on bail. That's the implication of section 46 sub 1 and 2. If somebody is arrested and produced before a foreign court and the matter for which the person is wanted involves death penalty, or it's a serious offense, armed robbery, murder, kidnapping, and so on, that court, the foreign court, is not likely to grant bail to that person. But the bail will be better handled by the home court, the court that wants that person, because that court will have more of the facts, or be in a position to have more of the facts surrounding the case.
Okay, now we're going to take a very quick breather. When we come back, we will look at some other aspects of this section, and we'll round off the Wheel of Justice today. But before we go, just stay tuned. We'll come back. We'll be looking at other sections, other parts of this section, and also he'll be here to enlighten us more on what we need to know about this. Just stay tuned. All right, welcome back. This is Wheel of Justice. Don't forget, it comes your way 3:30 every Tuesday on Flow 94.9 FM, and it's brought to you by the Abia State Administration of Criminal Justice Monitoring Committee and Prisoners Rehabilitation and Welfare Action Power, with the support of Open Society Initiative for West Africa, OCWA, and Abia State Justice Reform Team. We'll be speaking about warrants of arrest under sections 43 to 49 of the Acjl 2070. This is the part 2 of it. Last week we looked at the first part of this, and I was speaking with a chief magistrate, grade 1 in the Abia State Judiciary, in person of His Worship OK Onoma. And before we've got very few minutes on the program before we round off, but we got to look at sections 48 and 49 under this arrest warrant section. And 48, if you permit me to read this part out, 48 states, where a suspect in lawful custody escapes or is rescued, the person from whose custody he escapes or is rescued, or any other person may pursue and rearrest him. So that is well understood. Now, but if we go to 49, it says the provisions of sections 13 and 14 of this law shall apply to arrest under section 48 of this law, although the person making such arrest is not acting under a warrant and is not a police officer having authority to arrest. So the confusion might come under section 49.
No, it's clear. 48 says where a suspect is arrested and one way or the other he escapes, that the person from whose hand he escaped can
chase
pursue him, yes, and rearrest him or get hold of him. Then 49 offers a kind of protection for that person. 49 makes sections 13 and 14 of the same law to be applicable to that situation of 48.
Can we have an idea of what sections 13 and 14 are?
Yes. For example, it's those rules for arresting a person fresh. Those rules for arresting a suspect are fresh. Applies
without a warrant.
No, with a warrant.
Okay.
Applies in arresting a person who escapes.
Okay.
For example, if you need to break into a house where you suspect that person is, you are protected. You can go in and get hold of him.
Okay.
If you go inside the house to arrest that person and they lock you in, people do it. You could come into a compound to arrest a suspect who flee into that place. They will go and lock the gate. The law allows you to break the gate and come out. Yes, and you will not be guilty of any offense. So sections 13 and 14 of the law, Acjl, in kind of reinforces the protection given to somebody who is trying to rearrest a suspect that is fleeing.
Okay.
So by saying you can break out if you are locked in, you can break in and arrest the person. You can inform the people in the house in the area, so and so felon or person or suspect is being pursued by us. He has entered this place. We want to arrest. All other rules, like if there are women within the compound or premises, you need to inform them. Please, perhaps dress up, or if you don't want anybody to see you, mind where you should be. We are coming in to arrest so and so person who escaped.
On a lighter note,
those rules apply. You will comply with them. That's the implication of saying rearrest under this section.
All right.
We'll have sections 13 and 14 applying.
Okay. Now, we are out of time already. We're out of time. But on a lighter note, while the police officer informs the women to dress up, wouldn't the suspect have gone very far? Anyways, thank you very much for coming through. I've been speaking with His Worship OK Onoma, who's the Chief Magistrate, Grade 1 and the Abia State Judiciary, and he's been helping us understand Section 43 and 49 of the Acjl under the warrant of arrest, part 2 of it. Thank you very much for coming to our studio.
My pleasure.
All right.
Thank you very much.
All right, this is all we'll have to call it today on the program Wheel of Justice. Also have to say a big thank you for to Kelechi Imo, who's always coming to observe. He's representing Prawa right here. And my name remains Ifanye Awa. Don't forget the program comes your way Tuesdays from 3:30 p.m. It's brought to you by the Abia State Administration of Criminal Justice Monitoring Committee and Prisoners Rehabilitation and Welfare Action Prawa, with the support of Open Society Initiative for West Africa, OSIWA, and Abia State Justice Reform Team. Till next week, please continue to obey the law.